Okay, so I'm going to assume there's a lot of people out there without videos. So good afternoon. Thank you for joining us on our COVID-19 employment seminar. We have muted all of the participants for the presentation. We ask you to stay muted so you can listen to our speakers uninterrupted. I'm Mary Doherty. I'm the Executive Director of the Gulf Coast Builders Exchange. We have our Education Chair, Jared Hawkins, who helped us put this together along with Ryan Owen from our Education Committee. So I want to thank all of them and Albany for their hard work. We are asking through the presentation, because we have about an hour, maybe a little more. We're a little loose on the back end if we need to be. But we ask that you use the chat box to submit questions throughout the presentation, and we'll get to those at the end, or if there's an opportunity throughout the presentation. But there will be a question and answer period at the end of our discussion today. And we will be sending all of the attendees a follow-up information flyer with bullet points from the event and contact information for each of our speakers. We are very fortunate today to have three very esteemed speakers with us and two wonderful sponsors who made this event possible. So I'd like to thank our sponsors, Norton Hammersley, Scocos PA, and Atlas Insurance. Our three speakers today are Benjamin Briggs, Cottney Construction Law, who will be covering workplace safety. Jason Collier from, I shouldn't have switched pages there, I apologize. Jason Collier, Shoemaker, Loop, and Kendrick, who will be speaking about employer-employee legal update. And Joseph Herbert, Esquire of Norton Hammersley, who will be talking about COVID-19 within the workplace. So in the interest of time, again, thank you to all of our speakers and our Education Committee. We'd like to get started with Benjamin Briggs, Esquire of Cottney Construction Law, talking about workplace safety response to COVID-19. Thank you.
Good afternoon, everybody. Thanks for being here with us today. I'll be speaking about workplace safety as it relates to COVID-19, and I'm going to try to kind of go relatively quickly, hit on the high points. And of course, we'll have a Q&A session at the end. You can follow up with anything that you might have, any gaps maybe in what I gave to you today. But that being said, it's important to kind of understand up front, when I talk about workplace safety, I'm speaking about your office, I'm talking about the job site, and I'm also talking about the transportation that your employees might have transferring from one job site to the other, from home to the job site, between your office or warehouse and the job site. So there's a number of different locations, if you will, that I'm talking about when I speak about workplace safety. And we're going to kind of touch on each of those because there's kind of a different standard or different, requirements or recommendations when it comes to your office versus your job site versus those traveling in between. But what's kind of important maybe to kind of clarify right up front is that you're not going to hear me talk about a lot of laws today, a lot of statutes, a lot of ordinances. There's not a lot of actual formal laws or regulations governing COVID-19 in the workplace. What we instead have, for the most part, are federal guidelines, federal recommendations. And again, that's what most of what we're going to be talking about today is. So just kind of understand up front, a lot of times I get questions about what does the law require me to do in this situation? I have an employee tested positive for COVID-19. What am I required to do? And frankly, there's not a lot of legal requirements out there. Instead, we have a lot of recommendations that we'll be going through. With that in mind, it is kind of important maybe to mention right up front that OSHA does have a general duty provision that requires all employers to provide a workplace that is free from recognizable hazards. Now, it's possible, again, this is a pretty new, COVID-19 wasn't on the scene last year. We're still in the early stages of this. The law hasn't caught up yet. It's still to be seen whether or not OSHA will try to extend the general duty provision to COVID-19 related issues. Again, the general duty provision requires that employers provide a workplace that is free of all recognizable hazards. Beyond that, OSHA does, if you go to their website, they do have a number of things about COVID-19. They're issuing newsletters about COVID-19, but keep in mind that what OSHA has on its website, the newsletters it's issuing that tells you you should do this, you should do that, none of those are actual regulations. Those are not enforceable laws. OSHA cannot give you a citation based on anything on their website or on a newsletter that hasn't actually been formally brought into the federal code. So again, we don't have a lot, that OSHA requires as far as COVID-19, but there is that general duty provision that's worth noting, and you want to kind of, to play it safe. What I recommend most of the time, and I'll be talking about mostly today, is complying with what the CDC recommends, because for the most part, OSHA's guidelines out there are just derivative of the CDC. They're basically, asking employers or directing employers to comply with the CDC. So the CDC, the Center for Disease Control, is a federal agency, and they've putting out a lot of information, a lot of recommendations and guidance out there for employers. And we're going to go through all of that in a minute here. One quick note with respect to the CDC is that the information they're putting out is literally interim guidance. That's what they call it. That's what it is. It is guidance. It is recommendations, not law, and it's interim. It keeps changing. So they have a website that has a lot of good information on it, a lot of good resources on it. And what you want to do is continue to have your team continue to review the CDC, review their updated recommendations, their updated guidelines, their updated standards, because those continue to change. It's a bit of a moving target. So what I'm talking about today, a month from now, might have changed a little bit. So keep that in mind. Now, the CDC has a number of different things that they advise employers to do to make sure that their workplace is safe as far as hygiene and sanitation goes. One of the main things is to make sure that common areas, the break room, reception, common areas or commonly used equipment or tools are cleaned and sanitized regularly. Again, that's a way to prevent the spread of COVID-19 between your employees and potentially between those who come into your office to visit customers, third parties, could be vendors that are in there. So cleaning a common area, again, is one of the main things that the CDC recommends. In addition to that, there's obviously the recommendation of social distancing. And social distancing can be accomplished in a number of different ways. For starters, if you have employees who are able to work from home, you should consider allowing them to do that. Some employers have even required employees who can work from home to do so, again, to try to limit the interaction from person to person within the office. So if that's something that you're able to do, you might consider doing that, because that's a form of social distancing that can help prevent the spread of the virus. Beyond that, when it comes to, I mentioned earlier, common areas, break rooms. If you have employees who are using break rooms within your office, for lunch, for example, you can limit the number of people you allow in there at a time, maybe stagger the lunch breaks, again, to try to create that 6 feet of distance in between people, which is what the CDC considers to be social distancing. In addition to that, if you're having meetings, try to do virtual meetings versus in-person meetings where you're all in one room. When it comes to vehicles, a lot of construction contractors have crews that are traveling all around, and a crew generally, is traveling together in 1 or 2 vehicles, which generally means that you have multiple people in one vehicle. If you're able to, you might want to consider having multiple vehicles going to the same job site to limit the number of people in any given vehicle. Again, that's another way to create social distancing, which is what the CDC recommends that you do to the extent you're able to. However, it may not be possible. I mean, we have a lot of issues, obviously, with only so many of your employees maybe are actually registered to drive, or they have a valid driver's license, or they're covered by insurance, or they just don't always have operating vehicles. So we understand that, in large part, you might not be able to have everybody show up to the job site in their personal vehicle. And in that case, what you want to try to do, to the extent you have employees who are going to be traveling together in one single vehicle, is, to the extent possible, have them social distance within that vehicle. So if you have a couple of people in a vehicle, have one in the driver's seat, have one in the back seat, kitty corner of the guy driving. Again, it's just doing what you can do in that instance. Beyond that, you can have the employees who are in the vehicle wearing a mask to try to limit the exchange of germs or of the airborne pathogens while they're in the vehicle. You can try to clean the surface of the steering wheel or the handle of the car door handles. Things like that, again, are what the CDC recommends. If you have to have employees traveling in one vehicle, try to do what you can to make that workspace, because again, if they're traveling for work, it's considered a workplace. Try to make that workplace as safe as possible. And again, these are different recommendations that the CDC has to try to make the workplace that you're providing for your employees as safe as possible, which again can potentially go to the general duty clause of OSHA, which requires that employers provide a workplace that is free of recognizable hazards. And, the backdrop of everything we're talking about today, or at least everything that I'm speaking about today, is number one, you want to try to prevent the spread of the virus within your workforce, because obviously if you get a couple of people to go down, all of a sudden, your business can be grounded. You can be late on projects. You can have to shut down a project. We're trying to avoid that interruption to your business, which the spread of COVID-19 creates. Beyond that, if you're able to put all these different implementations, all these different safety measures in place, your workers are going to feel more comfortable going to work. Your customer is going to feel more comfortable having them show up at the job site. And, the contractors you're working with are also going to feel more comfortable. So part of it is to try and prevent the spread of the virus. Part of these precautions are to try to make your employees and your customers and the contractors you're working with feel more comfortable having you guys go about your daily business operations. And the third consideration is trying to limit potential liability. Again, we haven't had a ton of cases yet on this. Our firm, though, has had a few where a contractor is working on a home, somebody there gets the virus, and they're trying to sue our client contractor, holding them responsible for the virus that the resident contracted. And one of the ways to try to limit that liability, or at least create some good defenses, is to show all of these different measures that you had in place to restrict the transfer of the virus within your workplace, so that if somebody does get the virus, you have a good argument that they did not contract it due to one of your employees. They must have contracted it somewhere else, because look at all the measures you have in place. With that being said, there are some additional important measures that you want to consider taking, again, to create and maintain a safe workplace. One of the main things that you can do to create a safe workplace is to obtain information from your employees that will let you know whether or not they might have the virus. Being able to screen out employees from your workplace who could have the virus is an important way to create a safe workplace. In addition to all the hygiene and sanitation suggestions or recommendations we just discussed, keeping people with the virus out of the workplace is probably the primary way you can create a safe workplace. And there's a couple different ways you can do that. Kind of a quick disclaimer with regard to this specific topic is that, normally speaking, prior to COVID-19, you would not hear me advising you ask your employees personal medical questions. I would not be advising that you undertake medical examinations such as temperature checks. Under normal circumstances, these are not the kind of things employers are supposed to be doing. However, this is not a normal situation. This national pandemic is nothing at all it is not business as usual. And the federal government acknowledges as much. And the Equal Employment Opportunities Commission, the EEOC, has actually come out and specifically said that employers are permitted to ask their employees COVID-19 related questions. Employers are also permitted to do medical examinations of their employees, such as pre-job temperature checks, to determine, again, whether or not the employee may have the virus or not. And if the employee refuses to answer those questions, or refuses to take the temperature check, or if the results of the temperature check or the results of the employee's answers to your questions, if any of those indicate the employee may have the virus, you are allowed, legally speaking, to keep them off the job site. Now, it's important to spend a little bit of time at least looking at what you can ask your employees and what you can't, because although these are different, kind of extreme times we're living in, it's not carte blanche. You still have various things that do limit what you can ask your employees. So kind of the first thing to keep in mind when it comes to asking your employees about their medical information, COVID-19 related questions, and also taking temperature checks of them, is that this is just supposed to apply to those of your employees who are actually in a shared workplace. So if you have employees who are working remotely who aren't actually coming into contact with your employees, do not ask them medical questions. Do not make them take temperature checks. But for those of your employees who are going to be in a shared workplace, they're going to be at an office, at a job site, in a car with other people, those are the employees that you can go ahead and you can ask them medical questions, such as, have you tested positive for COVID-19? Do you have any of the symptoms of COVID-19? You can run through the various symptoms with them. You can ask them, have you been exposed to anybody who tested positive for COVID-19 or who has the symptoms of COVID-19? One thing you want to try to avoid asking them is, has anyone in your family tested positive or have the symptoms? Because again, you can ask them whether they've been exposed to the virus, or you can ask them whether or not, even if anyone they're living with has tested positive. But you want to avoid asking them specifically about their family, because that can potentially go to the genetic information that employers are not supposed to be asking about. And again, with the temperature checks, you can do daily temperature checks. And when an employee has a temperature of 100.4 Fahrenheit, that's kind of the threshold. If they have a temperature at or above that, they're considered to have a fever or a high temperature, which is one of the symptoms of COVID-19. And at that point, the CDC recommends that you send the employee home to quarantine. And one kind of final thing to say about the employee information that you're obtaining to preserve a safe workplace. One final thing to kind of say about that is keep in mind that the information you receive, although you're able to ask these questions and to take these temperature checks when normally you're not able to do that, you are still under the same obligation to keep the employee information you obtain private and confidential to the extent possible. So what that means is, the employee who obtains, if you have an employee who reports to you they're COVID-19 positive, whoever that employee is reporting to, that person is supposed to keep that information as confidential as possible. Any information that you have about an employee's symptoms, what they report to you, what they answer on a questionnaire, what their test results are, that should all be saved in a separate file that is just containing their medical information. Federal law requires that to be you basically have to retain it in a separate file for them. And moreover, when it comes to you discussing that with anyone, to the extent possible, if you have to tell one of your employees, oh, by the way, you might have been exposed to COVID-19 because somebody else tested positive, you're supposed to do so to the extent possible without identifying the individual who did test positive. Because again, that information that you're allowed to obtain because of COVID-19 is still confidential private information that belongs to that employee, and you can be liable if you are disclosing that confidential information outside of your management department or your HR department. Those that are on a need to know basis have the right to that information. Nobody else does, generally speaking. And again, I know there's a lot we covered. There's a lot more that can be discussed with respect to workplace safety, and you can bring that up in the Q&A section at the end. But I want to turn it over now to Jason, who's going to talk about some of the different employment laws that have come into place because of COVID-19.
Thanks, Ben. And thanks to everyone for participating today. Thank you for including me as a presenter. My topic today really is focused on the Families First Coronavirus Response Act, which we refer to as the FFCRA. And as Ben mentioned, we too could spend an entire multi-hour seminar just on this topic. I don't plan to get into that level of detail either. So this will be a really high level overview of the law so that you'll be able to spot key issues hopefully going forward, and you'll know how best to respond to protect your organization, to protect your employees. I do have a PowerPoint which we're going to scroll through. I think this topic lends itself nicely to a PowerPoint. So if I can ask Albany to share her screen, that'd be great. Thanks, Albany. On the first slide, if we scroll to 2 slides ahead, actually. So the FFCRA was signed into law in March of 2020. It took effect April 1st, 2020. So this law has been around for about 3 months. As of now, it's slated to continue through the end of this year. And there's been lots of discussion as far as whether or not it will be extended. As of now, it's still too soon to tell. It's going to depend on what happens with COVID over the next few months here. There are 2 distinct pieces of the FFCRA. We'll talk about each of them. there's a paid sick leave requirement that employers are obligated to follow. And there's also an expanded FMLA, or family medical leave, piece as well. With respect to the paid sick leave, the first question that comes up is, okay, which employees are eligible? And the answer is all employees are eligible. So this applies to full-time employees. It applies to your part-time folks. It would apply to temporary employees. There's no minimum period of employment that's required for someone to be eligible. So this employee could have started working for you last week, and if they qualify for paid sick leave, and we'll talk about what criteria they need to meet in order to qualify, they would be eligible for paid sick leave. In terms of which employers are covered, there are two requirements. One is an employer that engages in interstate commerce, and that is a term that's very broadly defined. Virtually all employers will meet that test. You know, if you accept credit card payments, if you're using telephones, if you're accepting goods that at some point have crossed state lines, you're going to be engaged in interstate commerce. So most employers can assume that they're subject to the first criteria, and the second one being if you employ fewer than 500 employees, then you're also subject to this paid sick leave law. Now, there is a small business exemption. If we can go to the next slide, please. It's a very narrow exemption. So if you're an employer with fewer than 50 employees, and if you can prove that complying with the FFCRA would jeopardize the viability of your business, then you have the opportunity to try to meet this small business exemption. I can tell you that the burden will be on the employer to prove that complying with this law would jeopardize your viability as a business. From everyone I've spoken to, I think most practitioners think this will be a quite narrow exemption. But how do you know if you, what factors would you look at to prove or establish that you should be eligible for this exemption? The DOL has listed 3 different factors, which I have on the slides. The first one being, if you as a business can establish that complying with the law would result in expenses and financial obligations exceeding your revenues and cause the business to cease operating at a minimum capacity. The second factor being, if you can establish that the absence of this particular employee or this group of employees, if multiple folks have requested sick leave, if that would entail a substantial risk to your business operating due to their specialized skills or knowledge. And the third factor being that there just are not sufficient workers available to perform the services. And if you can establish that, that would give you another argument. Again, you want to be quite confident that you can demonstrate these factors prior to assuming that you qualify for the small business exemption. Just because you may have 15 or 20 employees, and just because it might be burdensome to comply, that is not going to be enough. You need to be able to show that this would jeopardize the viability of your business. And most practitioners think that the vast majority of small businesses will not qualify for this exemption. Next slide, please. What are your obligations, assuming that you're a covered employer? It's to provide paid sick leave. So if you have an employee who is not able to work, or they're not able to telework for any of these 6 reasons, then they're eligible for paid sick leave. So the first reason being, if an employee is subject to a federal order, a state order, or a local order to quarantine or to isolate. So the example there is the stay-at-home orders that we saw. Second, if an employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID. So if you have an employee that brings you a doctor's note that says, I have a respiratory condition or I have asthma, and the doctor suggests that I self-quarantine due to COVID, that employee would be eligible for paid sick leave under this second prong of the test. The third reason is if you have an employee who has symptoms of COVID and they're seeking a medical diagnosis. Now, we had the question recently, what happens if an employee is ill? Let's assume they have all the symptoms. They have, a fever, a sore throat, a cough, everything right down the line, but they don't seek a medical diagnosis. They just stay home. Are they eligible for paid sick leave? And the answer there is no. They're not eligible under the FFCRA, at least. Now, if you have a company policy, they may be eligible under your company policy, but they need to be seeking a medical diagnosis in order to be eligible for paid sick leave under the law. The fourth prong, which is on the next slide, if an employee needs to be away to care for an individual who either is subject to one of those stay-at-home orders or who's been advised to quarantine by a doctor. Fifth, if an employee needs to care for a child of theirs because school is closed or because a child care provider is unavailable due to COVID. And sixth, the last reason would be an employee has substantially similar conditions specified by the Secretary of Health and Human Services. We haven't seen guidance along those lines yet, but that's included in the statute, so I wanted to make sure that it was included in your materials as well. Okay, if we assume that someone's eligible for paid sick leave, what are we talking about here? How much? For a full-time employee, it's 80 hours. For a part-time employee, it's the number of hours they would have worked on average over that 2-week period. And if you have employees who have numbers of hours that fluctuate over time, if they vary, then you're allowed to use the 6-month average. That's what the DOL instructs you should do to calculate the average daily hours. Next slide, please. In terms of the amount of paid sick leave, there's 2 different amounts that employers are required to provide. If the paid leave is for reasons that were on the first slide, reasons 1 through 3, then the paid leave is the greater of what the employee would have normally earned, the regular rate or the minimum wage, but it's capped at $511 per day, or over the 10 days, it's capped at $5110 per employee. And if the paid leave is for any of the second 3 reasons we saw on the second slide, then the employee would be entitled to 2/3 of the greater of their regular rate of pay or the minimum wage. This is not to exceed $200 a day or $2,000 in the aggregate. How do you determine the regular rate? It's determined by dividing the total remuneration, the total compensation that you would pay an employee in a work week, divided by the total number of hours that the employee works in that week. That calculation will give you the regular rate. Now, what happens if an employee is able to telework or they're able to work remotely? How should they be paid? They would just get the normal wages that they would receive. So if you have folks that can work remotely, then they're not taking leave under the FFCRA. So the paid sick leave that we're talking about would not come into play. What happens if you have other company leaves that your organization provides, whether it's vacation time or sick leave or PTO or personal leave or anything like that? How do those laws interact with the FFCRA? The paid sick leave that I just outlined is in addition to any other paid leave that your company offers pursuant to company policy. And the employee gets to choose which one they take. So the employee can choose to take paid sick leave first before they take vacation time, for example. They can do it in the other order if they choose. Employers can't dictate that employees exhaust vacation first, for example, or exhaust PTO first. That's not permitted. Employers also can't require, sometimes we say, listen, if you want to be absent, you need to find someone to fill in for you if you're going to be gone. We can't do that here. So employers can't require that employees find a replacement employee or find someone else to cover for them in their absence. So I know I've gone fast, but that's a quick overview of the sick leave portion of the FFCRA. The second piece, again, of the law is the expanded FMLA portion of the law. And this is a new leave that's available under the FMLA. As we probably know, prior to the FFCRA, in order to be covered under the FMLA, an employer had to employ 50 or more employees. That's now changed for purposes of this law. So for purposes of this law, a covered employer, again, is defined as any employer that has fewer than 500 employees. The same narrow small business exemption still applies. Which employees are covered here? It's a little bit different than under the paid sick leave, where they're eligible immediately on day 1. Under the FMLA portion, an employee needs to be employed at least 30 days to be entitled to the leave that I'm about to describe in the next couple slides here. What are your obligations under the expanded FMLA portion of this law? It's to provide up to 12 weeks of leave to employees. Unlike under the sick leave portion, where there are 6 different reasons we saw that an employee can qualify, here it's just one reason. Only if the employee is not able to work or telework because they have a child of theirs who can't go to school or whose child care provider is not available due to COVID. So that's the only reason when the expanded FMLA portion of the law comes into play. Can an employee take both sick leave and expanded FMLA? And the answer there is yes. However, it's only for a total of 12 paid weeks. So they don't get 14 weeks of pay. The maximum would be 12 weeks of pay. And the way it works in practice, next slide please, is for the first 2 weeks, the employee has the option of taking the paid sick leave, which we discussed, or they can substitute any paid leave that your company policy may provide. And for the following 10 weeks, the employee would get paid 2/3 of their regular rate of pay, capped again at $200 per day. And why would someone maybe choose to take vacation time under your policy instead of paid sick leave under the law? Because depending on what the reason is for the paid sick leave, it might only get paid out at 2/3, and they might actually do better by taking some of their vacation time, for example, or personal leave if you offer that as a company. So that might be a reason why an employee chooses not to take the paid sick leave right off the bat. Okay, intermittent leave. The FMLA has allowed intermittent leave for quite some time. The question arose here is, well, can employees take intermittent leave under this new FFCRA? And the answer is yes. The DOL is encouraging employers and employees to work together to try to be flexible. They've released guidance saying that they're going to be very supportive of these voluntary arrangements which combine teleworking and working, or combine working and intermittent leave. And I have an example on the slides here. If you have a situation where an employee whose child, let's assume that we were still in school, and an employee says, I can't work because school is now closed. I need to take care of my child 2 or 3 days a week. The DOL has said, absolutely, you can have an arrangement where the employee works, for example, on Tuesdays and Thursdays, and Monday, Wednesday, and Friday, they take intermittent leave to care for their child because the school is closed. So the DOL is encouraging these voluntary arrangements. Another example could be, for example, if you have an employee that tests positive, but let's say the employee has no symptoms, they're still going to be required to quarantine, right, for the 14 days. If you have some work that they can do remotely during that 14-day time period, then they could work for part of that time period. And if there's not work for them to do during part of that time period, they could take intermittent leave for the portion of the period when they're not working. So again, the DOL has said they'll be very supportive of those types of arrangements. Now, a big concern for employers is who's going to pay for this, right? And there is, fortunately, a tax credit available under the FFCRA so that employers can offset the cost of the paid leave provisions. And this credit is equal to 100% of any paid sick leave or paid FMLA leave that the employer provides. There are certain rules, there are certain limits. The IRS has certain restrictions. So this is something that you'd want to partner with your accountant or your tax advisor to make sure that you're checking all the boxes that the IRS requires. But my understanding is the IRS has been expediting refunds, and that they've even said that employers can deduct from certain funds that they would otherwise send to the IRS. For example, for payroll taxes, they're allowed to deduct the amount of the credit directly from what they would otherwise send into the government. In terms of documentation, it is important that you have sufficient documentation in your file to confirm that the person is eligible for leave so that you can get the tax credit in case there was an audit. There's some documents that you need regardless of whether you choose to grant or deny the request. So you would need to include the name of the employee. You would need to include the date for which leave was being requested. Why was the employee requesting leave? What was the reason? And you'd want to document a statement from the employee that they're not able to work because of this reason. There's additional documentation that you'd want to think about requesting also. It would depend on the reason for the leave, so it's a little bit variable. But if someone took leave, for example, because their healthcare provider instructed them that they should quarantine, you'd want to document the name of the healthcare provider. That's what the DOL regs say. If you're taking leave, for example, because childcare is unavailable, you would want to document the name of the employee's child, the name of the childcare provider, and you'd want to get a statement from the employee that there's no other suitable person available to take care of this child. And a question that has come up is, how should the employer dig? What if we don't necessarily believe the employee? How many questions should we ask? If the employee provides this information, I would say it's not something that you need to investigate much further at this point. That's going to likely be sufficient for the tax credit. And the concern is if you were not to believe the employee, for example, saying that they need this leave, and if you ignored their request for leave, then you can get in a situation where maybe you've run afoul of the FFCRA or a possible retaliation claim. So you don't want to require the employee to jump through a bunch of different hoops in order to get this paid leave. Another question that's come up recently is, what if I want to pay my employee at 100% instead of 2/3 for the entire 12 weeks? Can I do that? And the answer there is yes, you can, but you wouldn't get the tax credit for the amounts that are in excess of what the limits are under the FFCRA. So absolutely, you can pay them more, but the tax credit will be limited to the amount that's authorized under this law. Next slide, please. How about returning to work? What happens after the leave is over? An employee is entitled to be returned to the same position or an equivalent position. That's what this law says. There are certain exceptions. Again, these exceptions are also narrow. So for example, if you had a layoff while this employee was on leave and this employee would have otherwise been subject to the layoff had they been working, then you're not required to restore that employee to the same position. So they can't do better than they otherwise would have done. But again, that's a narrow exception. Generally, you want to be working from the premise of these folks need to be returned to work once they're done with their leave. Next slide, please. There is an anti-discrimination and retaliation provision under the statute. So we can't be taking any adverse action against an employee. We can't be firing or disciplining or discriminating against them for taking leave or for requesting leave or for filing a complaint, helping another employee request leave. We want to make sure that we're not discriminating or retaliating against any employees. And what are some takeaways? This is our last slide. This law, as Ben said, is rapidly developing and evolving. This is something that you want to make sure you partner with legal counsel. This has been only in effect 3 months. The DOL also continues, like the CDC, to release new guidance, new Q&As, new regulations. We've had a situation where a question may not be addressed definitively currently, and lots of practitioners may believe that the answer is one thing, and the DOL then releases new guidance 2 weeks later to clarify an ambiguity in the law, and they say, no, here's what we meant, here's how we think it should be interpreted. So the same caveat that Ben mentioned, things can change very quickly under this law, so we want to make sure we're checking back, particularly on the DOL guidance. We want to stay tuned. This might take effect into 2021. We don't know yet. There might be a new law that comes in play effective 2021. And the last bullet here is don't be the test case. What do I mean there? I would not recommend that employers take a hard line here. There's still lots of unanswered questions. There will be case law that develops in the next months and even years. And you don't want to end up on the wrong side of a situation because we took a hard line when we really didn't need to. So it's important that we do everything we can as employers to try to comply with this law. I have a slide for questions. My understanding is what we're going to try to take those at the end. So I'm happy to answer any questions at the end, and I'm happy to stick around afterwards. If we don't get to your question, please feel free to reach out, and I'm happy to speak with you anytime. And I believe, Joe,
we have some questions in the chat section if you want to look at them before the end, but we will
sure.
back questions at the end. So you want to turn it over to Joe?
If you'd like me to address some of these questions now, Mary, we can, or we can address them at the end. What would you prefer?
Why don't we save until the end and we'll give Joe, because I think we'll generate more questions as we go, if that's okay.
Okay, sounds good. Thanks,
so
everyone.
Now we have Joe Herbert, Esquire of Norton Hammersley, who's going to cover COVID-19 within the workplace. So Joe, the floor is yours. Thank you.
Good afternoon, everybody. So obviously you guys have heard some great information from both Ben and Jason. I think you've got a great groundwork in both the requirements in order to try to make your workplace a safe place to come and do your job for your employees. And then Jason gave you a great background on exactly what you have to do under the law if your employees turn up sick. What I'd like to do is focus a little bit more on maybe some of the more realistic day-to-day nuts and bolts of exactly what you're going to be faced with as a contractor, as a subcontractor, as an employee of one of those, as an owner, construction manager. So what you have to look at right now is trying to figure out from the standpoint of your business, right? What do we need to be doing in order to prevent this type of issue? What do we need to be doing if a COVID diagnosis comes up for one or more of your employees, or maybe somebody else on the job site? I think the first place that we want to start is for all of your management and ownership group. You really need to evaluate first and foremost having a frank, open, honest discussion with your work crews, with your superintendents, with your PMs, and even all the way down to your laborers and the actual crew, guys and ladies on your crew. And I think the reason for that is there are a lot of people, it's not an insubstantial amount of people that are either sort of scoffing at the potential implications of coronavirus, that are scoffing at some of the personal protection requirements, and are not really wanting to follow those guidelines. They're either lax in their guidelines, or they're maybe in some cases ignoring them entirely. And while, there are, I think people have a right to be concerned about some of the reporting guidelines. For instance, some states are counting COVID cases as, maybe somebody that has just been exposed to a COVID case, and they're counting that as a live active case. That's not what Florida's taking the approach of, but there are some questions on how COVID cases are being counted, on COVID deaths, how those are being counted. But what you can't argue is this is an extremely serious issue that is only growing in terms of its scope. Right now, as we sit here today, we've got, Florida has 230,000 cases, 4,000 deaths. The US just broke the 3 million case mark, or is right at it today, with 131,000 deaths. As far as a lot of people very early on were of the opinion that a number of people were coming up with COVID had little or no symptoms. But as we go day by day, this is, as we all know, this is a novel virus. So we don't know all the implications of what can happen if you get it. In fact, I just saw yesterday a study is in its early stages in the United Kingdom, showing that people who had even mild symptoms are showing, in some cases, very serious neurological issues, brain swelling. They're experiencing issues with their psychiatry. They're showing up with dementia issues. So there are some very serious implications if you're not following the guidelines. So what you need to do right now is make sure that your crew knows, and your PMs, your supervisors know. Do what you want to an extent on your free time, but during work time, and encourage them to follow these guidelines at home as well. But obviously we know you're not going to convince everybody to do what they're supposed to do outside of work. Obviously, the perfect employee doesn't exist. But when they are working, they need to be giving you good communication about whether they are experiencing any symptoms at all. They need to be honest about whether they are feeling under the weather at all. And they need to be telling their PM, their superintendent, they need to be telling somebody, and they need to be notifying you so that you can take the proper action as soon as possible. Right now, the CDC guidelines they really don't know exactly how long you need to be exposed to somebody that is COVID positive before you really are at a much greater risk of contracting it yourself. Right now, the guideline says 15 minutes of close contact is enough for you to be considered somebody who is exposed to the virus if that person is either symptomatic or has tested positive, or if they were within 2 days of a symptomatic or positive test. So from the standpoint that you have in construction, you've got people working in sometimes close environments, especially in residential, but even in commercial, you've got people working near each other. They're traveling, as Ben said, in trucks together. So you need to be sort of taking steps right now, sharing tools less often, breaking the groups into trucks, separate trucks, and traveling to and from in a more spaced out group. You need to take those steps now, making everyone mandatory wear the face masks or face shields when they're working. I understand the face masks sometimes make it difficult for some people to breathe. They need to not be pulling it down over their nose, having it hanging off of their ear. Face shields might be a good way to work if you need to be able to have access to, visually and seeing, and not have maybe the issues of breathing as much. But people you as the manager, as the owner, need to be rolling out exactly how serious you take this from the standpoint of not only the business and giving these people an opportunity to continue working, because they need to understand if a group of people go down, it could shut down a significant portion of the company. It could shut down operations. It could get you postponed, basically kicked off or suspended from a job for a period of time. So for them, their personal safety and for the health and safety of the business as well as their coworkers and other people they're on the projects with. They need to be wearing this protection. They need to be using it. And a lot of times you hear the feedback is, I have a First Amendment right. Unless you are working for and under the government, or you are on a government contract or something like that, and a government employee is telling them that they have to wear face masks, it doesn't apply. You as a private business can and should mandate that your employees, without question, wear the face masks at all times, unless they're going to eat. I'd take a look at certain times where you see people aggregate in your job field. For instance, a lot of times guys take lunch. They're going to pull off their masks. The guys and ladies are going to take lunch. They're going to pull off their masks to eat. You need to be telling them they need to be spacing out and take it serious. PMs, project superintendents, other people like that are supervising need to make sure that if they see violations of that, they are taking it seriously and not just sort of laughing it off or ignoring it. It is a very, very serious issue, and a lot of people are going to get sick. We really only have 1% of the population right now that's positive for COVID. This could be much, much worse in the very near future. Right now, even as we sit, Walt Disney World is reopening its parks. So you're going to see a lot more people returning to their somewhat normal lives, and you're going to see a lot more exposure as we continue to go along, because I don't frankly see a rollback to any sort of quarantine at this point, unless things change just in a fashion that's so drastic that it's almost unimaginable. I don't think most people are going to agree voluntarily to go back into any sort of, even with a mandate, to go back into any sort of quarantine. So in order to prevent those dire types of consequences, you need to be making sure that all of your employees are handling this diligently. You also need to make sure that you are communicating with if somebody shows up with COVID, obviously it is under new OSHA guidelines, it is a reportable event, as long as if it appears to you, and they're giving some leniency with what information you have, but if it appears to you that several of your guys or ladies have come up with COVID at around the same time, it is probably work-related, or at least that's safe to assume. And so you definitely want to go ahead and report that to OSHA. You want to notify any employees that were on that crew or were exposed to those people. You want to make sure, as I think Ben and Jason both mentioned, you want to make sure that you're respecting the confidentiality. You don't have to tell them which employee was sick, but you need to tell them as quickly as possible, you need to stay home. You were exposed to somebody. You need to stay home for at least 7 days because you were exposed. If you have it, you show up with a positive test, you need to be out at least 2 weeks. And you were exposed to a coworker that has tested positive. You also need to be alerting, I would say, if your group is working around or near any other subcontractors and you are a sub, you need to notify the GC and have them notify the other subs that may have been infected. You also, if you're a GC, you need to roll out to your subcontractors and let them know. You need to be keeping me updated. If anybody on your crew, don't just replace them with another crew and not tell me that the previous crew is down with coronavirus and they all have it, or a significant portion of them have it. Communication between those groups is going to be absolutely key to not getting these job sites shut down, because this virus can spread rapidly and it can spread among a number of people in one instance. So it is absolutely imperative that you use those communications. You also need, in addition of notifying OSHA through your normal channels, there's a CDC website where you can provide notification to them, give the employee career field, the job type, and keep them up to date on basically do the reporting through them as well. If you're interested in following up, there are also local health organizations that you can provide notice to. None of that's required. I certainly think it's a good idea, obviously, to notify the CDC, and you must, if it's work related, notify OSHA, because it's part of the covered portion. Also, I'll mention on OSHA, as far as if it's work comp related, in that this is it's a potentially was contracted on the job site. There are protections in place depending on how this guidance comes down. If it continues to be treated in exactly the same way as other types of workplace injuries, if the illness is covered by work comp, potentially, then you also have protection as an employer from liability for the employee being put in a position where they were near other employees. We have no idea at this point. I don't think any of us on this panel have any idea what's going to happen with some of the liability lawsuit where employees either express that they legitimately don't feel comfortable or are expressing that they maybe not as legitimately expressing that they're concerned about being in the workplace and would like to actually be working remotely, even if it's not feasible for you as an employer, where you force, and you are absolutely entitled to force your employees, unless they resign, to force your employees to return to work. And you want to make sure that you're following all the safety guidelines that Ben laid out. You want to follow all of the guidelines under the Families First Act and the extended FMLA that Jason mentioned. You want to make sure you're following all of those. But if your employees are healthy and the workplace, you're using proper safety protocols, you can enforce the fact that if you're the type of business that it's not really feasible to have your employees working remotely, or groups of your employees working remotely, you can make them be in the workplace. I think we will see a round of lawsuits in the near future starting to pop up where employees were forced to return to work and be in the workplace, ended up contracting coronavirus, and want to sue the employer for being negligent in forcing them to return if they didn't have to. So that may be something that happens out there, but if it's something that's covered by work comp, you do have immunity as an employer from those types of lawsuits. So that's something to be aware of. You, as Jason mentioned, you want to take a partner in legal if you have these types of issues come up, because these are sticky. Things are changing on a near daily basis, if not daily, at least weekly. Guidance isn't fully formed. It's coming out and rolling out in phases. It's being amended. So the legal footing on a lot of these things is still on a little bit of a shifting sands sort of platform at the moment. So there are a lot of issues that we're all wrangling with. But the big things are, you want to make sure that you're, as Ben mentioned, you want to make sure you guys are wearing PPE and protective equipment, that they're using that you're doing proper reporting. If you have an employee show up sick, as I mentioned, you need to be notifying all the other employees that were exposed to them within the CDC guidelines. And as I mentioned, not notifying them of that person's identity, just telling them it was a coworker. You'll also need to probably clean the workplace. If they were in the workplace, you'll need to clean tools and equipment. The CDC recommends that you wait 24 hours, not let anybody in that area use those tools, handle that equipment for 24 hours in order to prevent the cleaning people from coming into contact with airborne virus and pathogen. So that's the recommendation. But the cleaning crew should be wearing even more full PPE, face mask, apron, using the approved cleaning supplies. You can use soap and water. They also recommend there are a number of disinfectants that are on the CDC website. And those can be used to disinfect your tools, your equipment, and any area where people are working. As I mentioned, direct, open, honest, and frequent communication is key. You want to do that both up and down the chain of command. You want to do that with your partners on the job site in terms of other subcontractors, GC. You really can't be overly communicative when it comes to providing information about a group of positive tests or suspected positive tests, because we want to make sure that for all of us, that in order to continue working and continue to be out on the job site doing our thing and keep the projects up and going, which is in everyone's interest, we want to make sure that a small outbreak doesn't turn into a job site wide outbreak. As I think Ben mentioned, you could have PMs Supervisors do an external temperature check at the beginning of the day. It's really not too much of a hassle. Have them, do it in the morning when they're going to do their meeting before they get started. If you want, as Ben mentioned, if you're above 100.4, you have a fever, even if it's intermittent, and so you need to be sending that person for a test at that time and isolating them. And I would certainly go ahead and go forward with cleaning and protocols and try to make sure that you're isolating the chance that other people are exposed to it until you find out whether it's a positive test. But all of these are steps that we all should be taking, and making sure that employees understand and are educated about how risky behaviors can be. It's just like any other type of workplace risky behavior that employees sometimes we've all seen it. Guys not tying off that are working on the roof, working on high areas, and they're not tying off properly. People not using safety equipment properly. These types of things happen all the time in the real world. And it's our job, and it's your job as a manager or owner, to make sure that your guys and your ladies understand that this is just as serious in many ways as those types of behaviors on the job site. And if they see them, they need to be squashing that type of behavior. People gathered without masks, things like that. It's going to be one of the things that I think all of us realize, that we're going to look back, and history books will have a section about this. So just like Jason said, you don't want to be the test case. You don't want to be the example of how not to go about doing your job, especially when it can have, you're talking with the stuff that Jason covered, going out of pocket to pay for leave for employees that test positive. And by the way, the under 50, that's going to be tough, I think, for employers to make sure that they're doing everything to show, because I think the government is going to probably take the stance that it needs to do everything it can to protect employees, and it's going to probably construe that in favor of coverage for employees. And the government's going to recognize that basically every business is at risk to a greater or lesser extent right now. And so that's a huge potential outlay of cash and expense if you have to start covering employees in a group that have tested positive and have to all go home on leave. So it is 100% in your business's best interest to get very aggressive and very serious about prevention, about response, and about that type of behavior that's going to limit and lessen the chances that your entire crew or other crews are infected and shut down your company, your workplace, your job. And the employees need to understand that it's in their best interest as well if they want to continue to have a place of work. They need to understand that it's as serious in life and death, and as serious as their ability to continue providing for their families in one way or the other, either with your company or just in general, if they're not taking these precautions seriously.
Joe, great information. Thank you, Joe, Jason, Ben. We've had some good questions come in as you guys have been speaking. I think, there's a common theme here. We all want to do the right thing. We've been fortunate to be designated as an essential business, now doing what we can to get to the day where we say, remember the pandemic should be the goal. So all those safety precautions are extremely important. So again, thank you. So let me go right to the questions. Our first question, and I'll open it up to the three of you, whoever one of you wants to take it. It did come in while Jason was speaking. If a worker in a vehicle has an elevated temperature and is turned away from the job site, should the people in the vehicle with them also be turned away? Second question, if somebody on a crew tests positive for COVID and they were working alongside others in their crew, what is a good recommended course of action for that crew? Do not have them on site as well?
So those are good questions. I'm happy to take a first stab, and if Ben and Joe want to tackle it also with their thoughts, great. My own personal thought is it's going, and I hate to give the legal answer, but it's going to depend on the facts and circumstances. If it's a vehicle where, it's a truck and you have someone sitting in the back of the truck, in open air and the driver is the person that has the temperature, maybe there's a different judgment that's made than if everyone is in a smaller vehicle, in a confined vehicle where they've all been sharing the same droplets. Are they wearing masks? Are they not wearing masks? So I think we need some more information potentially, but in terms of the most conservative advice, it would be, if the person with the temperature or people that were congregating with the person with the temperature, now is not the time to be at the work site. I think that addresses the first question. On the second question, if someone tests positive and they're working alongside others, what's a good recommended course of action? My own personal thinking is, as was shared, we wouldn't disclose the name of the person that tested positive, but I think it's a good idea to notify the coworkers that are there to say, hey, listen, and they may know who it is just based on depending on the size of the crew. But we have a coworker who's tested positive. We wanted to notify you immediately so that you can take all reasonable precautions and seek medical attention if appropriate. And I think that's totally appropriate to send that type of message to coworkers that may have been in close contact with a crew member who tests positive.
All right, great.
Great response, Jason. I might add on to that. If it were me and I were dealing with the situation, I would certainly send the employee who's exhibiting certain types of symptoms. If he's got an elevated temperature, I would send that person home, and keeping in mind that the test may not show a positive result for a couple of days until you're after you've been actually exposed and become positive for COVID. The test may not show it for a few days afterwards. So I certainly would send, if I had somebody that came with elevated temperature or other symptoms, I would send them home probably for the week and then have them get tested a couple times until we find out if they are testing positive for COVID or not. As Jason mentioned, depending on whether the other people in the truck around them have been following the proper protocols, and they need to be honest about that when you ask them, and understand that they need to be honest about it. If they were taking proper protocol and precautions and separating themselves, as to the extent possible, and wearing masks, then I probably would maybe make it a little more serious for them and tell them not within 10 feet of anybody else, do not ride with anybody else. They are to be kept completely solo, not sharing tools with anybody else, and maybe keep them on the job, but making sure that they are sort of watched like a hawk to make sure they're using all their PPE and not near anybody else until you find out about a diagnosis or they show any symptoms. You could send them home, but that's probably not necessary if everybody's doing what they're supposed to be doing before that.
All right, great. All right, our next question is regarding one question on sick pay. If an employee is off because they were exposed to COVID-19 outside of work, but they don't get tested until their third day off, when is the first day they should receive sick pay?
I guess that one probably falls to me also. I would not be strict there if there's all sorts of reasons we're hearing why people may not get tested the first day, whether it's because of I couldn't get into my doctor's office on day one, or there were lines around the corner. So if someone is seeking a medical diagnosis, that's the language in the statute. The fact that they sought the diagnosis or the test on day 3 versus day 2 or day 1, I would allow them to start taking the sick pay on the first day that they were off of work, provided they were trying to seek a medical diagnosis.
Okay, great, thank you. On to our next question. I have an employee that was about to be terminated for well-documented attendance issues. Then they got sick. They are at home pending COVID-19 results, and I've been paying them under FFCRA for 5 business days thus far. I have to terminate them as soon as they are able to return to work. Since I am paying them for all this time off, I am viewing that when they return, all regular rules apply. I don't think I need to be concerned about letting them go, as we've kept up all our employer obligations, but I just want to know if there is anything else I should consider. I'm putting the attorney on the hot seat, as Jared said.
I'll jump in. So from my standpoint, I think anytime you have a situation as an employer, I'm going to assume for the moment that you're an employer, that obviously everybody's under the Family First Care Act. So from the standpoint that when you have this situation come up, I'm always worried about a retaliation claim. It sounds like you've done your due diligence on making sure that your file is properly documented. The issues are documented. The counter argument that's going to come up is, well, if they were immediately terminable at that point, they probably should have been terminated before the virus hit. If you were ready to terminate them, the argument is going to be by them, well, it's because I took the time off and you had to pay me, and so you retaliated. You may face some claim on that by terminating them immediately upon their return, or as soon as they're ready to return. I think it helps that you obviously have followed the law and provided them the time off, even though you were ready to terminate them. You paid them the time off anyway. I think that's helpful to you. But I'll tell you that it always, and I think probably Ben and Jason would agree, it always makes me nervous when an event that could trigger a retaliation issue happens right immediately before a termination, because almost assuredly a plaintiff's attorney is going to make the argument that it was as a result of the taking of the leave or whatever other activity was going to trigger potentially some sort of retaliation claim. Proper documentation is great. Proper communication, I would take a partner in legal and talk about exactly how to deliver that message. But it should not, in theory, stop you from terminating a bad employee that you have properly documented needs to go. But man, it's you're almost asking for a claim. So it's definitely risky. You need to, I think, evaluate, and probably legal will tell you, we need to evaluate whether maybe we want to make sure that there's more documentation, give them some time back and let them see if they have rehabilitated their issues or something like that. I know for my clients, I generally try to give some period of time between the event and the termination.
All right, great. Thank you. Our next question: if someone tests positive in the workplace, what is considered being exposed to that person? And is it a requirement or suggestion for anyone exposed to quarantine? If quarantining is suggested or required, does that employee use accumulated sick days or FFCRA sick days?
I can try to do a little bit of stuff here instead of putting it all on Jason and Joe. So I think actually Joe mentioned that the CDC's guidelines right now say that what they consider to be exposed is that the individual was within 6 feet, which is close contact, within 6 feet for a prolonged period of time. And the CDC has gone ahead and said what we're considering a prolonged period of time at this point is 15 minutes or longer. So if you have somebody who in the workplace tests positive for COVID-19 or is exhibiting the symptoms, the next question is, who have they been within 6 feet of for 15 minutes or longer? Because those are the people that the CDC considers to have been exposed to the individual with the virus or with symptoms of the virus. But again, the CDC is a guideline. It is guidance. It is a recommendation. It is not a law, which I think was part of the question. There is no requirement, legally speaking, when it comes to how you treat an exposed employee. But there are these recommendations. And if you're trying to take the cautionary approach, trying to be as safe as possible, the safest course is to comply with the CDC recommendations.
All right, great. Thank you. We also had an area where people could ask questions as they were registering. So I'm going to jump to one of those questions right now. And it was regarding face mask use. We may have touched on this. I think Joe said employers can require employees to wear face masks, but why don't we circle back to that and make sure it's coming from you and not my interpretation?
Ben, do you want to jump in? I can.
Yeah. Sure. I mean, one thing to keep in mind is that it kind of depends where you are, because some counties have mask ordinances. And for example, Hillsborough County, Pinellas County, I think Sarasota City, but not the county. So some of these are going to be a local kind of a patchwork of ordinances. And the ordinance themselves typically apply just indoors. So as far as masks go, if you're going to be indoors in a vehicle, in a building, depending on where you are, the law may require you to be wearing a mask. And as an employer, you are required to mandate your employees to comply with that law. Otherwise, you'll be subject to civil penalties, monetary penalties. Beyond those ordinances, because again, they don't apply everywhere, and they don't apply to your employees who are working outdoors on a roof or installing something outside. So there's going to be areas where the law is not going to be requiring you to wear a mask, and that's when you simply have to rely on whether or not you want to require them. You have the ability to require your employees to wear a mask, provided that they do not have a bona fide disability that prevents them from doing so. And again, most of the ordinances that I referenced earlier make specific expressed exceptions for those who have a disability. If someone has a breathing problem, if they have a disability, and wearing a mask could potentially implicate that disability they have, then the law, the ordinances do not apply to that individual. And your requirements, if you choose to require employees to wear masks, likewise should not apply to any of your employees who might have a disability that prevents them from wearing a mask. But other than that pretty narrow situation, you do have the ability to require any of your employees to wear a mask.
Okay. And then we had one more question as people registered, and they wanted to know about employees who refuse to return to work based on fear alone.
I'm happy to take that one first, I guess. So very common, right? We've heard this a lot where employees have expressed, and rightfully so, a concern. Legally, you as the employer have the right to require your employees to work. I mean, that's the legal answer. From the practical side, if folks can work remotely, telework, if we can stagger shifts in some way, if we can do other things to reassure the employee that we're taking this seriously, here is an acknowledgement that I want everyone to sign showing that here are the steps we're taking. We're going to require folks to wear masks. We're going to require hand sanitizing when you come and when you go and throughout the day. We're going to require traffic to all go throughout the location in a certain direction so that people are trying to minimize, face-to-face. Whatever steps you can show that you're putting in play to your employees that this is serious, we are taking this seriously. The hope is that will alleviate some of the concern, and then employees that are otherwise fearful will then at least be comfortable to come to work. But general fear alone, unless they qualify for one of the provisions that we talked about for leave, generally just fear is not going to be sufficient to require an employer to put someone out on a leave of absence.
Okay. All right, back to the questions from the folks who've been participating. If a relative of a key employee tested positive, can the key employee put on a second shift? Can the key employee be put on a second shift, I think they want to say, working alone to maintain business while waiting the results of the tests?
Well, from the CDC's perspective, again, the issue isn't whether or not a relative tested positive. Just to be clear, I have relatives, brothers, sisters who live many states away. What they look at is if whoever tested positive, were they exposed to the individual in question? So, if the employee of yours, a key employee, was, again, per the CDC's guidelines, were they within 6 feet of this relative for 15 minutes or longer while the relative is believed to have had the virus, that's when that employee is now deemed in the eyes of the CDC to have been exposed. And you're supposed to exclude them from the workplace. Now, if you're going to be balancing their shifts so that they don't actually come in contact with anyone else, I would advise that you do the extra step as well as making sure you clean thoroughly any area that they might use, that when their shift's over, somebody else is going to come in and use as well. Because again, part of keeping them out of the workplace is not simply their physical interaction with people, but it's also the germs that they will be spreading within the workplace if you allow them to come in, even on a shift where nobody else is present.
All right, great. Thank you. On to our next question. If you can ask certain personal health questions of each employee during this time, can you also require they get tested for either the active virus or the antibodies? And if I can kind of tag on to that one, another question somebody had asked me, can you also ask your employees anything about their off work time and if they've been, doing anything that might have put them at a higher risk?
I know I spoke in my opening, so to speak, I talked about what questions you can ask employees. And before I forget, one quick thing to mention is the CDC's current guidance still is advising employers to not require their employees to get tested. They're still taking the position that our medical facilities have limited resources available. So if the employee wishes to go get tested, they have every right to do so. But employers, according to the CDC, are not supposed to require any employee to get tested. So that kind of goes to that element of the question. But as far as what you can ask the employee, you can ask the employee any COVID-19 related question that will help you determine whether that individual working alongside other people exposes you to the virus. So again, you don't want to ask any of these questions. You don't want to ask any of these questions to an employee who is teleworking, who isn't actually coming in contact with somebody else. You want to reserve them only for those who are working alongside other employees. But you can ask them during the weekend, during your time off, did you test positive? Did you exhibit any symptoms? Did you come in contact with somebody else who tested positive or exhibited symptoms? As long as the question you are asking is, again, obtaining information that will help you determine whether or not that person working at your facility or on your job site will be exposing others to the virus. As long as the questions you're asking go to that, you can ask the question.
Okay, great. Now on to our final question. So if anybody has any other questions, I would ask that they type them in now. Otherwise, this is our final question. There is a mismatch between my employee name and SSN number, and I can't e-verify him or her. Does sending him or her for a COVID-19 test open up any additional risks for me as the employer? I'll try this between barks, sorry. If I'm a subcontractor to a GC on a public job and my employee tests positive for COVID, who do I notify? Owner, GC, other subs, OSHA?
I'll handle the second one there. We'll do that one because that dovetailed with what we were just talking about. I think it's important to go ahead and notify if you get positive tests in your shop. I would definitely notify if you're a subcontractor. I would definitely notify the GC. If you're in contact with, if you're working very closely with another subcontractor group, then I would notify them. Otherwise, I would ask that, when you notify the GC, tell them, listen, we're expecting you to notify the other subcontractors. And that's part of the open communication we talked about. You want to make sure also that your GC is notifying you of issues that are coming up with other subs. I would notify other employees that were working in close proximity with this person, that were exposed to them. I would notify OSHA. And you may want to notify the CDC as well. But those are the main ones.
I can try to address the first one. Yeah, I think these are two unrelated issues, really. If there's a mismatch, that should have been an issue that was hopefully addressed prior to, and if not, it is what it is. We can't turn back the hands of time, right? So if there's a mismatch situation going on, that's a separate issue that needs to be addressed. But I wouldn't let that dictate how I went about encouraging someone to get tested or telling someone to take some time off if they were exhibiting symptoms. So I would try to keep those issues separate to the extent I could as the employer.
Yeah, I would agree with Jason. I don't think it's going to do you any service to start ducking guidelines, for proper treatment of your employees because you're aware that there's an issue. I think it only makes you look more problematic potentially. If you have that issue, I would definitely suggest take a partner in legal to see if they can help you navigate that, and trying to rectify that issue as quickly as possible as a separate item.
Okay, so we had two more come in. So the first one is to clarify, an employer is not allowed to require an employee to get tested before returning to work.
That's going off of probably something, probably what I said earlier. Just to be clear, I'm talking about the CDC's recommendations. So it's not saying that an employer is not that it's illegal or improper for an employer to require an employee to get tested before returning to work. But the federal government, the federal agency, the CDC, is recommending that employers do not require a test before returning to work. They provide again, the employee is free to get tested if they choose to, but they are recommending that you do not require it. They provide an alternative, basically, option for assessing when an employee can return to work if there is no test involved. So again, you can, if an employee does leave work because they tested positive or they exhibit the symptoms and they choose to get tested again, if they get 2 negative test results that are at least 24 hours apart, they can return to work per the CDC recommendations. But alternatively, if the employee does not get tested, what they tell you to do is wait 10 days or longer from when the symptoms first appeared. And if after 10 days or more, the symptoms are gone, the person has been fever-free for at least 72 hours, 3 days. If that's the criteria, if that's the, what's going on, they've been fever-free for 3 days, it's been at least 10 days since their symptoms first appeared, then they can return to work without any test ever being performed. And again, they are recommending that you not require your employees to return to work, but there's no law out there that says you cannot do that. There's not any law you're violating if you choose to require your employees to get tested.
Yeah, so on that, just very briefly, I think the CDC sort of talks out of both sides of its mouth sometimes a little bit. That's my personal opinion. And so in some respects there, if you're looking at their guidance on making sure that your workplace is as safe as possible, to answer your question, can you require your employees to get tested if they show up with any sort of high level exposure or they've got symptoms? Yes, you can require that. And if the CDC says, well, maybe you shouldn't, that's up to you. I certainly, if it were my business and one of my employees and they work like in construction, they're working in the field together side by side, elbow to elbow, shoulder to shoulder sometimes. If it were my company, I would require it. If somebody showed up with symptoms, I would require it before I let them back.
Which leads us to our next question. What if my employee doesn't want to get tested because he is undocumented? She is undocumented. How to complicate it?
Yeah, so this is a follow-up on the Social Security mismatch question from earlier. I think as Ben just mentioned, you're not obligated to mandate that your employee get tested. So if your employee is out and hasn't exhibited symptoms for the 10 days that have passed since first exhibiting symptoms, no fever for 72 hours, and they otherwise are feeling better after quarantining for 2 weeks, if you don't want to send them for testing and require testing, you're not legally obligated to do that. Again, my preference would be to keep these as separate issues, and I would apply kind of the standards the same for everyone. So unfortunately, some of us may have multiple employees that are going to fall within a similar situation in terms of symptoms, and I wouldn't send one person for testing but not a second person. So whichever path you choose, I think you need to be consistent, and I wouldn't recommend changing the path because someone is undocumented.
Okay, last call for, well, it's not a question, but they're reading my mind. So you three did an awesome job with the Q&A. Really appreciate your time today and allowing us the benefit of your experience. Thank you, Jared. And you guys did. I think we heard a common theme. We all want to keep a healthy, safe workplace so we can keep business going, so we can keep the economy going, taking those precautions, making sure that employees are not exposed to one another if they've been exposed to COVID. Doing some of the simple things that are going to keep your business open are very important. I put in the chat box earlier, at GCBX, we have free face masks if you need them for your business. We also have hand sanitizers, so we want to help you do your part in keeping everybody healthy. And hopefully, not that you should all stay on for this long, but if you want to come back and join us, 5:30 tonight, we have our GCBX virtual happy hour. So we would love if all of you would join us. And then we are going to have an outdoor, socially distanced, in the fresh air, GCBX Sunset Kayak Tour on Thursday, July 30th at 5:30. All levels are welcome. Everybody can do this. We're hoping everybody stays healthy through this. We're hoping this ends sooner rather than later. And again, I'd like to thank our education committee. I'd like to thank Albany for being a great facilitator of Zoom today. And I'd especially like to thank Benjamin Briggs, Esquire of Cottney Construction Law, Jason Collier, Esquire of Shoemaker Luke Kendrick, LLP, and Joseph Herbert, Esquire of Norton Hammersley. We are going to have a one-page information sheet that we're going to send to everybody that attended today, as well as GCBX members, and we have recorded this session. So we will be putting this on our website if you needed to look back at a certain segment. Guys, thanks. There's so much confusion out here, and I know it's changing daily. So thank you for your expertise, and something tells me with this as an evolving situation, we may be calling on you again as it continues to roll out. So thank you so much.
Thank you, guys.
Thank you.
Thanks, guys.
Stay healthy.
Thanks, everyone.